Your hosts have earned a reputation as fierce and effective advocates inside and outside of the courtroom. Our partners are experienced trial attorneys who have been board certified in family law by the Texas Board of Legal Specialization.
Thanks for tuning into For Better, Worse, or Divorce podcast, where we provide you tips and insight how to navigate divorce and child custody situations in the state of Texas. So I'm Jake Gilbreath, and today I'm joined by one of our outstanding associate attorneys, Priyanka Bins, and we are going to discuss both the legal, kind of personal and emotional aspects of going through a divorce when one of the parties is pregnant in the state of Texas. So welcome back, Priyanka. I know you've done this podcast before, so thanks for joining us.
Yeah, thanks for having me. Excited to be here.
All right. So I tell people that I think some of the hardest cases that we do are when you have a divorce or a child custody situation with a child under the age of 3, and I think it gets harder the younger the child is. What's your experience with that?
Absolutely. I think just having a child and going through the pregnancy and the childbirth is stressful enough. And then to add kind of this big life change where you're separating things out and moving out of one home into two, it can get complicated. Absolutely.
Yeah, really complicated, both legally and emotionally and everything. Really, so for everybody involved. If it's
Sure.
if it's a heterosexual couple, having represented a lot of dads going through this situation, it's sort of scary, and you're, already speaking as a dad, already feeling out of control, and as if you're not contributing much to the situation. Probably because you're not, and by comparison, but you have this unknown out there of what's going to happen, and then I can't imagine, Priyanka, I'm talking to you as a mom and also as a lawyer I can't imagine what it'd be like going through it while pregnant, or we have a very young child. But it's something that happens, and we're there for people no matter what led to the situation that you find yourself in. So let's, I guess, Priyanka, talk sort of basically if somebody's going through a divorce during pregnancy. So what kind of special circumstances does that cause if one of the parties is pregnant and one or both of them wants to go through the divorce and a divorce is filed?
One of the first things I want to know when I'm representing someone who's pregnant is I want to know what the circumstances are in the home. How are things going? Are the two of you amicably determining that you're going to get a divorce, or is this something that we need to take more serious considerations? Is there violence going on in the home that we need to take into account? Those are all things that I want to hear about first. And then we can determine a course of action to decide, how are we going to make sure that everyone's comfortable? How are we going to make sure that dad is preserving his rights while mom is, ensuring that the baby's okay and that she's taking care of her health and her mental health and physical health. So those are all concerns that I initially have when I meet with the client who's expecting. And I think when there are issues of family violence, that kind of takes you into a different path, right? When you're planning a divorce where you're expecting a child and there's family violence, you're not just going to file for divorce and then wait for the child to come and finalize the divorce. There are a lot of other things that you're going to consider. So those are my first steps, and then we can make a course of action after that.
Yeah, and I like on that how you kind of start with the kind of physical safety and then kind of emotional safety and well-being. It's already a difficult time. Then obviously, in any divorce, physical safety is a priority, but looking at the emotional safety of everybody involved is really important. I'm the same way, right? It's what's come up with a plan and what's come up with what's practical, prioritizing safety. But sometimes people, they're separated when they're coming to you, or they're talking about separation. And then all of a sudden your birth plan looks a whole lot different for both sides involved, looks a whole lot different than maybe what you were planning. If it was a planned pregnancy, it may look, or y'all had planning involved in how you're going to do the birth. So it's just something to talk about. Though, Priyanka, sort of legally though, and you mentioned a little bit like in family violence situations, but let's say there's not family violence where you're not filing for a protective order, but you have somebody that's going through a divorce, and sort of from both perspectives, what can you tell? And let's say it's a heterosexual couple, so you have a mom and a dad. What can you tell them about what legally can happen while during the pregnancy before the birth, and then I guess taking up to the actual birth of the child?
Sure, yeah. So there are certain things that you can accomplish during the pregnancy. You can't necessarily get divorced, but we can start that process. We can file for divorce. We can try to get some temporary orders to get certain things in place. For example, when I'm representing a dad and they're expecting, then I want to make sure that the dad is involved in the prenatal care and in making sure that he's doing his part to cover prenatal expenses. Any sort of, hospital or doctor's visits, that generally dads want to be included in those. So you want to make sure that you can get that taken care of. And then when you're representing mom, it's kind of the same. I mean, you want to make sure probably primarily that the prenatal expenses are taken care of. Those can get very costly even with insurance. And then you want to make sure that she's comfortable with how things will play out when the child comes. So, for example, I've had several cases where we've mediated just on the issue of, is dad going to be in the room when the child is born? Is dad going to be at the hospital? Is he going to be allowed to be alone with the child after the birth? So those are all things to consider and to ask an attorney about if you're in that situation.
Yeah, those are all really good points. Because a lot of people may not think about all those things. I mean, maybe it's your first child and you haven't thought about those things, period. Or even if it's the second or third child or what have you, most people haven't thought about what's this going to look like if we're separated or going through a divorce or what have you. But so I think it's a good point. It's a lot of practical considerations to think about if one side's pregnant, and then the pregnancy is going to have, I mean, the birth of the child is going to happen while the case is pending. I mean, from the, again, represent both moms and dads in this situations. I do get the legal questions sometimes. I'm sure you do too, from dads in a heterosexual context, or if you're in a same-sex relationship, non-biological mother who's not carrying the child, right? Let's say it's a contentious divorce or a contentious separation or custody case, and somebody asking, well, I want to be there for the birth of my child, so can I force it? And that's, the legal answer is no, you can't. It's a medical procedure. Ultimately, at the end of the day, for the mother, it's highly personal and private. She may not want you there for your family, and so no, you can't force it. But that goes back to like what you were saying, Priyanka, is there's ways that we can do it where even if there's not this legal backdrop where I can force something, like a litigating over a 5-year-old child, hopefully we can work out a possession and access schedule. But if we can't, at the end of the day, I could go to court. I can get a court order that says, here's when I get to see my child. That's not the situation for the birth of the child and being there as part of the birth plan, the child being born. And so we're really more looking at sort of practical from both sides, like you were saying.
Yeah, and you're dealing with a sensitive. I guess it's time sensitive, so you need to move quickly, and you're not. You're also handling other issues, most likely. Property issues and splitting up of bills and all the other things that you have to worry about in a divorce, and then to have to also kind of come up with a birth plan that works for both parents in a manner of, hopefully 8 or 9 months, but generally it's going to probably be more like 5 or 6 months. The amount of time that you're going to start planning and figure out what to do.
Well, let's talk about a not fun conversation that we do have to have with our clients. Do you talk to your clients, prospective dads, about DNA tests when they're going through either a divorce or a custody case?
Yeah, absolutely. I mean, that is something that comes up, and generally, I'm the type of lawyer that when I'm talking to a client, we're going to talk about everything, uncomfortable or not, because I need to know to ensure that they're protected. And so, in cases where parties are getting a divorce, either right after finding out that they're pregnant, I think it's important to ask, is there any concern there that maybe there was some infidelity or any concern that you would want a DNA test to be done? Because if there is no DNA test that happens, then the court's just going to presume that husband is father. That's just kind of automatic. And so without taking those steps, you're essentially waiving any, opportunity to bring someone else in who may be responsible for this child.
Yeah, it can be a really sensitive topic, as you can imagine. I usually, from a practical perspective, I usually tell clients, we're the ones asking for a DNA test. I usually tell the clients, blame it on me, or I just say, well, my lawyer said I have to do this. If the other side has a lawyer, they'll explain it's something that just has to be done. It's just, it's all of us, because we've always obviously seen the situation where somebody assumes that they're the father, maybe legally they're presumed to be the father, and it turns out that that's actually not the case. I've had clients find out years later. I've had clients find out really like multiple years later, 8, 9, 10-year-old child, and they're finding out when going through a divorce. So that's it's an emotional strain doing it at the beginning. It's devastating doing it finding out years later.
Incredibly damaging.
Well, so let's talk about then, Priyanka, this. I would, again, going back to what I said at the beginning, I think one of the most difficult things to come up with. Let's say people are going through, they're separating right when mom's pregnant, child's born, or maybe they're separating a divorce when you have a child, an infant, maybe say under 6 months. I think those are some of the most difficult cases to come up with possession schedules. There's not something there's not a schedule in the family code that says this is what we presume the schedule is. Oh, how do you approach those cases? I guess from representing either side with coming up with a possession schedule, say for a baby that's under 6 months.
Yeah, so those are really important things we need to take into account, right? We're dealing with a child who is incredibly young and very dependent on his or her mother. And so in those situations, you want to make sure, I think the first thing as a mom that I ask is, are you breastfeeding? Because that is something that is going to require the child to be with mother, majority of the time. And so that is one of the first considerations I come up with. And then after that, we start to determine, what is a comfortable period of time where the child can visit with dad. Maybe not for a long period of time, but frequently. I think it's very important to have frequent contact, particularly at a younger age. So generally from, 1 day old to 3 months old, you want to make sure that there's frequent contact so that the baby can sense his or her father and know who that is and feel comfortable there. But there are a lot of studies that have said that that's really healthy for the child, and that we want to kind of limit the overnight and the extended periods away from mother and incorporate more frequent kind of shorter periods of time, and that's good for everyone involved. So those are some things that I like to discuss with my clients. And then, of course, if things are a little bit different, if mom wants for father to be more involved, or maybe there's no consideration of breastfeeding, maybe dad can do the bottle feeding, then that makes it a lot easier to come up with a schedule, particularly if the parents live close to one another. I've had situations where a newborn is basically being passed back and forth from the same neighborhood because mom and dad live in the same neighborhood, and they both want to be really, really involved in the child's life. So it really just depends on personal preference and kind of how you plan to raise your baby.
Yeah, I think those are really good points, because, all cases, whether or not you're getting divorced with an 18-year-old, a 15-year-old, no kids or what have you, every single case, it ultimately is custom. Every single family is different. Every single arrangement is different. But I would say for younger children, for babies particularly, it really is particularly custom to the family, right? Like an 8-year-old, obviously every single 8-year-old's different. But, you have a child and they're in school, and we can kind of figure out for most children, if there's not special needs, we're going to be pushing a lot towards a standard possession order or a 50-50 possession order. Obviously, again, every single family is different. Every single case is different. But really, there is not a standard, like you were saying, for an infant. And there's so much to take into consideration. Are we nursing? Are we not? Where does everybody live? Safe households. Is everybody sober? Like you were saying, in an ideal world where everybody's safe, and let's say we have a nursing child, then you do have sort of these short, frequent visits for like in this situation, dad. And I've represented moms in that situation. I've represented dads in that situation where it can feel scary for the dad It's like, well, this is my child too, right? Like we made this child together. We were planning to raise this child together. I want to be involved in my child's life as much as possible. And it can feel kind of in your standard situation, it can feel like this isn't fair. I'm getting cut out. Why don't I matter as much? And again, every single case is different, but kind of counseling through that. It's like, this is not the schedule from now until your child turns 18. We're dealing with it with a baby. We're dealing with an infant that may have nursing needs that, father, you just can't fulfill. Sometimes we can if we're bottle feeding or pumping or using formula. But kind of, I guess, if I was going to say a theme, and correct me, tell me if you agree, Priyanka, I think the theme of doing a custody case with babies is trying, if it's safe, trying to lower the anxiety as much as we can on both sides. Because you're a parent, I'm a parent. It's really anxiety producing to have young babies as is.
Absolutely.
Going through this on top of it.
Yeah, look, it's hard to co-parent in a harmonious marriage. I mean, it's just difference of opinion. It's, being a first-time parent, never having done these things. And then on top of that, to add kind of this discord of, we're no longer living under the same roof. Maybe we don't even agree on the fact that the sky's blue. So how are we going to agree on what time the baby sleeps and how many months of breastfeeding we're going to do, or when he or she does his first sleepover, like that? Those are all things to consider. And I think with dads, it can be daunting because you just don't know how things are going to play out. So I always recommend to my clients, if it's available to them, or if it's something that the parties are both open to, is therapy, family therapy, to try and get through kind of what's a really new and stressful time, a happy time, but still stressful.
This conversation just reminds me, just kind of a point that I make with lawyers that come, are considering doing family law or come to work for us through family law. It's just what a great job we have at the end of the day, that we can kind of help people through this difficult time. When I'm talking, we do law school interviews where we have lawyers that are thinking about doing family law. They become clerk for the firm. So I get to talk to a bunch of first-year law students, second-year law students that are considering family law. And one of the stories I tell them is a case that I had, or a day that I had, really sort of towards the beginning of the pandemic. So everything was virtual. And I tell them this story to explain kind of how diverse the job is that we do. And there's a kind of a scheduling snafu, or something happened where a particular event had to happen on this day. So it ended up to where I was kind of two commitments on the same day. On one hand, I was appearing virtually in Travis County in front of a judge to come up with a possession schedule for a 1-month-old baby. And on the other hand, at the same time, we had scheduled a mediation for a divorce. And I had co-counseled the divorce, so it was fine. So they would kind of go back and forth between the two. But on the custody case that we were appearing in court, we were trying to come up with a possession schedule for a 1-month-old baby. And we were talking about nursing and nap time schedules and car seats and diapers and all this stuff. And I was using my training and legal skills for that. And then popping over to the divorce, we were talking about the sale of a business during the marriage that sold for $800 million, right? And it's the same. I mean, I'm being asked my advice and guidance on both of them. And it requires us to have experience in both those things. And they're both incredibly important to the family unit. I would argue that the possession schedule for the 1-month-old baby is way more important than what we do with the $800 million. And that we had that opportunity. I don't know about you, when I went to law school, I didn't think this is what I'd be doing, but that we have the opportunity to help families through this, no matter what their situation looks like.
Absolutely. I mean, at the end of the day, even though you only represent that one person, that one party to the couple, you're still helping an entire family trying to figure out, how are we going to navigate this together, and how are we going to make sure that everybody's comfortable and that this baby's life and new life is kind of the norm that you hope for. And so that's really important because it is emotional, and it can get emotional for me because I'm a mom. And so seeing that and seeing kind of how to make a difficult situation easier for everyone. It can be tough, but it is incredibly rewarding.
Yeah, absolutely. I agree with that 100%. Let's just power through a few listener questions. I want to get to these, and then we'll wrap up. So I had somebody wrote in, asked, from the divorce perspective, does the presence, they asked for the presence of an unborn child, let's say either a unborn child or a newborn, how does that affect the division of assets? And from the divorce perspective, Priyanka?
Sure. So, I mean, I think it is a consideration to take into account if the child has not been born yet, and maybe there's another child. Let's say that the older child is has a certain lifestyle or certain kind of, maybe they're going to private school, maybe they have certain extracurricular activities that will continue, and you're already expecting that the unborn child will kind of follow that path. Then the court can look at how the assets are going to be divided and what the custodial parent is going to receive versus what the non-custodial parent will get. And maybe it makes sense to ensure that the custodial parent is getting a disproportionate share to accommodate for kind of the needs of the children. I've seen that happen. I think in general, if it's your first child, I haven't seen a situation where the division of assets might affect the presence of an unborn child. I'm curious to know what your thoughts are on that. But generally, I think it would be more kind of let's maintain the lifestyle and ensure that the child is taken care of moving forward.
Yeah, I think that's a good way of putting it. I mean, of course, I'm going to give the it depends answer that we always lead with, but it's one of the many factors for the courts to take into consideration when they divide up the estate. I always remind listeners and remind clients, the court in the state of Texas doesn't necessarily have to divide the property up 50-50, and there's lots of different factors the trial court can take into consideration in making her division. So that could be a disproportionate, that could be a difference in earnings. That could be one side has more separate property than the other. It could be fault in the breakup of the marriage, and it could be custody arrangements. So even if you're probably wouldn't be getting divorced when there's an unborn child, but newborn child, even if we don't absolutely know what this child's life is going to look like moving forward, we a lot of times we have a sense, and it's certainly a factor for the court to take into consideration. Let me ask two more. So Priyanka, somebody asked, so said the baby isn't mine, but was conceived during our marriage. Does this make her responsible for the child in terms of custody and support? And you touched on this already, but let's go back to it because it is so important. So if it's not my child, but I'm married and my wife is pregnant, what's that mean for child support and custody?
Absolutely. So if you have any inkling that this is the case for you, then you're going to want to do testing, right? The first thing we need to do is get that DNA test done. In some situations, maybe a father was at the hospital for the birth and believed that child to be his and signed what we call an acknowledgement of paternity, an AOP. And if that happens, and then maybe later some information comes to light that he's going to want to get DNA testing, then he can do that. And then we would submit that test to the court to confirm that he is in fact not the father. At that point, the most important thing for father's attorney, and probably for mothers as well, is to bring in the actual biological father into the case as a third party. And then what will happen is you'll have the divorce kind of continue on with husband and wife, and then you'll have a suit affecting the parent-child relationship kind of grow out of that between mother and biological father. And so those cases, they can seem complicated, but they're really not. You're still creating a final decree of divorce that includes all the terms you need for property division and for the child. You're just doing so for a third party father who has been brought into the case. But that's so important, because if you don't do that and you finalize your divorce as if you are the father, you will be legally obligated to that child.
Yeah, I've seen that. I've seen situations, earlier on in my legal career, you'd have, maybe say in this situation, like dad's deployed, husband's deployed, and serving in Iraq, and the wife is pregnant, and they don't get a DNA test or adjudication that he's not the father because they're thinking, well, of course he's not, right? He was deployed when wife got pregnant. But legally speaking, even if the even if it was a biological impossibility, legally speaking, marriage leads to presumptive that the husband as the father. So it's just really important.
Right. Bottom line, someone will be responsible. So if they're not going to find the right person, it's going to be husband.
Yep. Let's do this last one. I'm going to modify the question a little bit from what the listener wrote, but we're talking about modifying custody arrangements after the child's born. That was the question. But actually, Priyanka, can you talk to me more about kind of how these possession schedules progress? So let's say you have a situation where newborn that's breastfeeding, like you were saying, so you have short, frequent contacts with the dad. Where do we go from there? Because that's not going to be the schedule, obviously, when the child's 18. So what does that look like?
Yeah, so these are very, like you had said earlier, these are very specific and custom to the family. So generally, I would say probably 95% of the time when I'm dealing with a newborn or a younger child, we settle these cases in mediation because parents really want control over where the child's going to be. And if you don't settle in mediation and you go in front of a judge, there's a huge chance that the baby is going to get, visitation with one of the parents through a standard possession order, which means immediate overnight. And you have not started sleep training. This baby probably doesn't really know how to sleep more than a few hours at a time. So those are all things that you want to think about before heading into court. So if you have the opportunity to reach an agreement, then you're going to start thinking about what are these, what we call stair steps of time that are going to be comfortable for my family. So in general, we'll probably do them in increments of 3 to 6 months, depending on how they're going. And essentially it's, okay, when the baby's born, we're going to have 3 to 6 months of the baby being with mom primarily and breastfeeding. And then we'll do, maybe dad will get, Monday, Wednesday, and Friday for 3 hours at a time. And that's every week. That way baby's getting tons of exposure to dad. They're having some bonding time together, but baby's still sleeping at home in his or her crib. So there's that. Then the next 3 to 6 months will probably look quite a bit different. We'll say that dad will get maybe Monday and Wednesday for a few hours, and then maybe we'll try all day Saturday. Because now you're looking at a 4 to 6 month old, an older baby who's probably more comfortable being away from the mother. And then as that progresses, we start inching towards a standard possession order. We want to make sure that the non-custodial parent is getting plenty of time with the child. And of course, a standard possession order means that they would be getting frequent weekends and holidays and things like that. So generally, I like to work up towards that at around, this depends on the family. Sometimes it can be in as early as a year. But most of the time, there's that 3-year mark where the parties will eventually work up to a standard or expanded standard possession order where dad will get quite a bit more time than just the frequent visits during the week.
And that is the magic age, right? Because in the family code, it says that's when the presumptions kick in as far as a standard possession order. But like you were saying, every case is different, right? I've seen judges or parties by agreement push it a lot quicker. I've seen people go a little slower. If there's a theme for today, it's every single family is different. And these are hard situations, but with an experienced lawyer and having the right attitude about it, we can help you through it. So really complex and the topic, one of the most important things we deal with. So appreciate you joining us today, Priyanka. That was great. And that's all we have for today. So as a reminder to our listeners, if there's a topic that you would like us to discuss on the podcast, or if you have suggestions or feedback for us, you can always reach out to us directly at podcast@waltersgilbreath.com. If you'd like to speak to a member of our legal team, including our amazing associates like Priyanka, you can find us at our website. That's all we have for today, and thank you all for listening.
For information about the topics covered in today's episode and more, you can visit our website at waltersgilbreath.com. Thanks for tuning in to today's episode of For Better, Worse, or Divorce, where we post new episodes every first and third Wednesday. Do you have a topic you want discussed or a question for our hosts? Email us at podcast@waltersgilbreath.com. Thanks for listening. Until next time.